Hello, this is U.S. Immigration Attorney Sharifa Tharpe. I am here live to take your questions, and we're also here live to go ahead and talk to you as we approach the inauguration. We're going to be talking about all the immigration changes to expect on day one of the next administration, as well as the issues and the changes we'll be experiencing throughout 2025. Uh, I'm trying to set up Instagram here. Hi there. Hi, Yari. It's nice to see you. I'm just trying to set up Instagram at the same time. Hold on. Let me see. I have to set this up so Instagram can see us at the same time. All right, perfect. Okay, so in the meantime, as we're talking, put your questions in the comments. We're going to be talking about what to expect from day one. I am here live with Attorney Bria and Attorney Deanna, who work with the law firm, and we work very closely together. Hi there in the Bahamas. We work very closely together to qualify our clients and also to work on getting our clients the work permits, the green cards, the relief they need to be here in the US. And it's more important than ever for us to talk about what to expect, but also to talk to you about the ways that you can protect yourself here in the US through the various types of relief that we need. So we're going to start by just talking about the changes that are coming on day one of the next presidency. And then we're going to open up the floor for questions. What I would say is make sure to put your questions in the comments from now. So as soon as we're ready to start answering questions, we will have those questions ready. All right. So Attorney Bria, we're looking at the Laken Riley Act. That is hitting the news right now. It's a major immigration legislation that is going to change a lot in regards to immigration consequences. So, can you tell us about that? Where are we on that act and what can we expect?
Yes, absolutely. So I'm thrilled to be here with you all today to discuss the Laken Riley Act. So this legislation has been a center of heated debates since it was introduced earlier this month. While the tragedy that inspired the bill, the murder of Laken Riley, is undeniably heartbreaking, the policy implications of this act are far-reaching and deserve close scrutiny. So, just to do a brief overview of the Act, the Laken Riley Act is an amendment to the Immigration and Nationality Act that mandates the detention of undocumented immigrants who are charged with theft, even in an absence of a conviction. It broadens the definition of theft to include offenses such as burglary, larceny, and shoplifting. And this even applies to minor thefts that involves $100 or more. The Laken Riley Act raises due process concerns as it mandates the detention of individuals based solely on charges, bypassing the presumption of innocence until proven guilty. But unfortunately, the act does not stop there. It grants state attorney generals the unprecedented ability to sue federal agencies, such as the Department of Homeland Security, to enforce these provisions. This creates a direct conflict with the supremacy clause of the United States Constitution, which mandates that federal law overrides state law when the two are at odds. With these constitutional conflicts in this act, we can definitely anticipate swift litigation over this provision if the act is signed into law. Lastly, this act also penalizes countries that refuse to accept their deported nationals by denying visas to their citizens. This act would override the discretion of detaining immigrants with a violent criminal record. So, with these legal battles playing out, it's essential for immigrants, especially undocumented immigrants, to understand how to protect themselves and minimize their risk of facing allegations that could lead to detention under the Laken-Riley Act. So, here's a few steps. So, seek legal advice, access legal representation if accused of a crime, preferably of an immigration attorney and a criminal attorney who will work together. Request a public defender if need be. Always exercise your right to remain silent. And here are also a few practical day to day precautions, such as avoiding self checkout. Unfortunately, these minor misunderstandings or false allegations or false accusations, such as theft allegations at the self checkout counters, can escalate under this act. Opt in for cashier checkouts instead, just for safe precaution. And also use your own debit card or credit card to ensure that your purchases are traceable to avoid any confusion or allegations of theft. Thank you so much for your attention, and I encourage everyone with questions or concerns to consult an immigration attorney to better understand how this act could affect you.
That's right, exactly. It's serious. This is a serious thing going on, and we want to make sure you're aware of it. So, even taking into consideration the practicals that Attorney Bria just explained to you, make sure you exercise those because we don't want any misunderstandings. We don't want you to have to face any unnecessary risk because this means ultimately what it means is even an accusation of theft can mean you will be mandatorily detained. It's not even an option. ICE doesn't have an option. This law will mean that you will face mandatory detainment pending your criminal prosecution and then deportation. And it also means once you're detained and convicted for this, you are deportable. So it's serious, and it does look like it is going to be passed. So the Democrats are proposing amendments, but it really looks like the main point of this, which is to expand I think the definition of theft to minor crimes like shoplifting is going to pass, and it is going to have that clear consequence. So please, everybody, don't take it for granted and make sure if you are caught in a situation where you are arrested, you must make sure you also know that in some criminal prosecutions, you are entitled to a criminal lawyer. You have the right to ask for a criminal defense lawyer, remain silent until you can speak to that defense lawyer, and then consult an immigration attorney and have the two attorneys work together to figure out what the best way to resolve your charges will be so that you don't face those immigration consequences. All right. Thank you so much, Attorney Bria. And remember, keep putting your questions in the comments so that we can answer the questions when we get to questions. Attorney Deanna, so we're also talking about, President Trump he has over 100 executive actions waiting to issue on the day of his inauguration. And many of those executive actions are related to immigration. But the main one, we want to talk to you about the main one that many are nervous about. Some people are even skeptical about it. But the advancement of Trump and the administration and his return shows us that we can't take anything for granted. We cannot X out any possibilities here. And so Attorney Deanna is going to talk about the potential termination of the birthright citizenship.
Yeah. Yes, absolutely. So another thing that has been going around is the potential end of birthright citizenship. So, President-elect Donald Trump has stated multiple times that he intends to issue an executive order on day one to end birthright citizenship. And so, what is birthright citizenship? And can a president unilaterally end it with an executive order? So, in short, birthright citizenship is, with a few exceptions, it just means that children born in the US do have a right to citizenship, as stated in the 14th Amendment of the US Constitution, also known as the Citizenship Clause. This means that regardless of your parents' legal status, if you're born in US soil, you do have a right to citizenship. With the executive order, President elect Donald Trump has stated that to qualify as a citizen and get citizenship, you do not only need to be born in US soil, but now you do have to meet new requirements. And this one is that you do have to have at least one parent that is either a US citizen or a legal permanent resident. With it, he could direct federal agencies to basically withhold passports or other documents and benefits that will basically make the person have to prove that they do meet this new requirement. But can a president end birthright citizenship with an executive order? The answer is no. It's not as easy as he says it is. He cannot just go directly and change the Constitution with an executive order. You do need to have it amended. So, in order for that to happen, President Trump basically needs 2/3 of the House and the Senate minimum to start just the amendment. So, with the executive order or legislation, he cannot just go ahead and do it unilaterally. That said, he still intends to go ahead and pass it. And if that were to happen, it will be unconstitutional. Aside from that, we do expect to basically have a lot of litigation in court because of unconstitutional nature, and denial of documents as well as benefits will be challenged as well. However, while all of this is happening, we do also foresee delays in obtaining any citizenship affirming documents such as passports. So, what can you do right now, seeing that this is a possibility and it is something that he has stated multiple times that he will do on day one? So, as of now, the best thing that you can do to be proactive in light that this could be a possibility in the future is to go ahead and apply for your passport. You and your child, if you do qualify for citizenship, go ahead and get ahead of the game, get ahead of them, be proactive. If you can act now, of course, we would suggest that you definitely do to at least mitigate anything that could happen in the future. As of now, that is the updates on any end of birthright citizenship with the executive order of President-elect Donald Trump.
Exactly. This is a controversial topic, and I agree that this is unconstitutional.
Mhm.
However, we do expect that there is going to be a pushback, and because of that, we're going to be going through a lot of litigation.
Mhm.
And it's similar to, for example, to DACA recipients who have been held as pawns, held hostage. They have not been able to get their benefits because of ongoing litigation.
Mhm.
And we expect the same thing to be happening when it comes to issuing passports and issuing proof of citizenship to children. Is children of undocumented parents, uh,
Mhm.
that they will start to delay the processing of this kind of documentation while the litigation is going forward. So
Mhm.
people will be affected, or there is a likelihood of being affected while
Mhm.
this controversy is moving forward.
Yes.
So, so keep that in mind, everybody. Just follow Attorney Deanna's directive, and just making sure that you try to get your passports. It's sort of late, but
Mhm.
we never know. Just stay ahead, still apply for the passport
Mhm.
before any kind of policies are implemented.
Mhm.
Yeah. All right. So, on my end, I want to cover the kinds of policy changes to expect throughout 2025. So as we go through 2025, what are we going to see? What kind of policies will we see that will affect the processing of your application? So even if you're applying for your immigration documents and seeking protection, how can you expect it, the way that is going to be processed, to change? I did practice during the last Trump administration, so I am aware of the changes that happened the last time. What the main changes I'm going to be talking about that we experienced the last time would be the public charge rule, increase in fees, uh, blocks to asylum work permits, as well as the implementation of fraud detection. And it's still there. They still have ways of detecting fraudulent activity in applications, but there's probably going to be a larger focus on fraud detection that's going to cause delays. And then the mandatory interview of immigrants in applications. Those were the processes that were in place that really created a severe backlog. So let's start with the public charge rule. Right now, so during the Trump administration, Trump had implemented a public charge rule that demanded a lot more information and analysis than the norm. So instead, normally, which is happening now, is you just submit a form, an I-864 affidavit of support form, from the petitioner, showing the petitioner's income, proof of income, to show that they can support the immigrant that they're sponsoring, their immigrant relative or spouse. However, what in the last administration, they went ahead and overhauled the public charge process by requiring completion of additional forms, and those forms required the extensive background information of the immigrant. So it would be a credit check. They would have to credit check, education check, employment check, age, health. So we're going to household size. We're going to probably see that come back. And with that, it means that it's going to be a lot more complicated. The I-864 is already a sticky point for many people when they're going through this process. Well, now they are demanding the kind of information that's going to require a more subjective review by the immigration officer. They're going to look at the totality of the circumstances. They're going to look at, for example, your credit score, your debt, to see how much debt you're in. They're going to look at your health. They're going to look at your age to see if you're more likely to be dependent on any kind of public assistance, right? And if they find that you are going to be, just based, for example, if you're sponsoring a parent and that parent is experiencing severe health issues, that's usually not a determination that the officer makes, right? They don't look at the health of your parents to decide whether they're going to get to give them the green card. However, in this case, what they're going to do is look at the health of the parent, and then they're going to look at the income, the household size, the debt, to see, is there a possibility that the family can't afford to pay for these healthcare costs? So they're looking into the future, saying, can you afford these healthcare costs that will be coming? And if you can't, then that means that your parent is inadmissible based on the fact that they don't have the ability to pay for their medical expenses. So in the last administration, what we saw was we had to start getting health insurance in place in order to show that the health insurance can cover the medical needs of the family member. So do you see how complex that can become? Well, for a family that has very limited means, they are not able to pay off their debts, possibly not get health insurance, especially if they don't have a social security number or legal status already. here in the US to be able to get health insurance. So that creates an undeniable obstacle to get to the green card. We probably will be seeing that coming back. Before it was, you had to fill out what's called the I-944 form and then attach all of that evidence. So it's going to be a lot harder to predict approvals because we're looking at a more subjective review. The officer is going to look at different criteria, different circumstances to just try to predict whether, based on these circumstances, a family, a petitioner, or an immigrant can afford to be here in the US. The other thing is fraud detection. So when I was practicing during the Trump administration, fraud detection, especially in marriage-based, was really in overdrive. And because of that, couples that really should have been uh, approved were accused of fraud many times. They would go through very tedious interview processes that was very intimidating. And by the end of it, some people would come out saying uh, they admitted to fraud when that was not the case. We probably will be seeing this hostile type of interview setting again in order to screen out fraud. In addition to that, even before you get to the interview, they're going to probably divert it to a fraud team who is going to look through the applications first. And they're going to look through every single factor in the application, every single question or answer to see if there are any kind of contradictions that could point to fraud. So that means ultimately we're going to have a lot of delays, unfortunately. Um, the mandatory interview. So right now, especially from marriage-based and family-based, they have been waiving interviews. Well, during the Trump administration, everybody had to wait for an interview. And that meant that a process that was really supposed to be 6 months turned into a 1.5 to 2 year process. And then, God forbid, you go to the interview, and because of the overzealous fraud detection, you go to the interview and it doesn't work out well, that could add another year to the process. So be prepared. I would say here, when I'm talking about the public charge rule, fraud detection, and mandatory interview, family-based and marriage-based applications are going to be very complicated. Do not underestimate how complicated this is going to be. Get an attorney and get ahead of the game. These, for example, public charge rule, it really has to be implemented through regulatory notice period, right? So that means that they are going to announce these changes and they're going to have an effective date. So one way that, for example, during the last administration that we got around those regulatory changes was we hauled butt to file them before the changes were implemented because we could see a set date. But I would say don't wait. Make sure if you know you have an option, don't wait, do it now, right? Because the President Trump does have control over the executive branch and the legislative branch and the judicial branch. So that means any changes that he wants, he can do it very quickly now because the roadblocks are very little for him, except for just the time that it takes to pass these new rules. Another thing is increase in fees. So, for example, asylum seekers had to pay for their work permits. T visa applications had to pay for their waivers. We're going to be seeing that happening again. Now, here's one ray of hope that I want to talk about, and that is when during the last administration, many of our clients who applied for VAWA, who applied for the TU visa, were exempt from these rules. So please take comfort in that. We don't know what changes are coming, specific changes, but they did preserve the ability for T visa, U visa, VAWA, and to a certain extent, asylum applicants to seek relief without the added burdens of proving the public charge, right? Proving income and the fees. There were no fees except in certain circumstances where you had to pay for a certain waivers to get forgiveness. But there is nothing that's going to be better than acting now, empowering yourself to schedule an appointment with us to go over your circumstances and to find the solution for you to be able to get your papers here and to get protection. I get this question. Will the work permit protect me? Will I be included in the mass deportation? The work permit is considered proof that you have permission to be here. So you ultimately do have protection while that work permit is valid. And as long as your case is going forward, you get to renew your work permit, right? And that means continued protection. That means that you get to go to work, you get to get your driver's license. If you're ever stopped, you can show that, and it would be seen as proof that you have permission to be here. So it's important to make sure that you see whether you qualify for this. So as the year goes by, I do want to reserve time for questions, but as the year goes by, please note that we will be seeing many changes. And the key to this is acting very quickly before changes occur, be updated on changes as they occur so you can stay empowered and stay informed. We're here. You can go to the description of the video on YouTube, Facebook, and also for Instagram. We didn't get to get Instagram on this live show today, but I'm going to repost this on Instagram. On Instagram, go to the link in the profile so that you can schedule your appointment. Attorney Bria, Attorney Deanna are here. We've been working together, working very closely to screen our clients, working closely to make sure our clients' applications are filed. So we will be continuing that work and finding solutions, because we're in the business of finding solutions for our clients. So give us a call and let's get started. Now, with that, let's go to questions. I'm going to go ahead and start with the questions. Hi, everyone. Thanks so much for your warm welcome. I'm going to this question. After T visa has been approved, can you get married to your girlfriend to bring her to the States? Yeah, that is possible. Your spouse does qualify for the T visa. So if you have a T visa, your spouse can come with a visa. Now keep in mind, if your girlfriend is outside of the country, the T visa does not give you the ability to just go back to the country and get married. So I don't know if that will be a hurdle for you. But once you do show that you're married, legally married, then your spouse qualifies for the T status with you. Attorney Deanna, do you want to take the next question?
Yes, I see here. Can an I-130 approved help with VAWA and the psychological evaluation help with your case? So it really depends on who filed the I-130. If it is a spouse and you're also filing, even if it is a parent or a child, if you're filing both of them, they might be in a discrepancy. Because if you want to show the I-130, if you have to show that there is a relationship with the VAWA, there's usually mistreatment. So you will have to show that there is not really a good relationship as opposed to what you will need for the I-130. So you will really have to see which one it is that you want to apply for. If they're for different family members, then we can definitely see that in consultation, see what your case looks like. But if it is for different people, definitely we can file for those. If it is for the same person, they're a little bit contrary one for the other.
Yeah. And then also I wanted to bring up this possibility that if say you filed an I-130 with the spouse, and then the spouse mistreated you, I-130 got approved, then the spouse mistreated you, and then you had to file for VAWA, then the I-130 can help to show the bona fides of the marriage. So that's that. But if it's I-130 that's not related, then it's not may not necessarily be helpful at showing in any way to your VAWA case. It might be different. And as Attorney Bria said, same with family. If you have an approved I-130 for a family member, then it can be helpful. But if it's unrelated, then no.
Yeah.
Attorney Bria, do you want to take one?
Yeah, I see a question. It says, can someone be eligible for T visa if employer doesn't give the social SSN benefits in the W-2? Please let me know. I'm not too clear about what Muhammad means by the SSN benefits. However, if you do have an employer who may not be giving you benefits that they may be giving an American citizen or someone who may be authorized to work here, that can be a case for T status. Of course, it would have to be coupled with some other things, such as, abuse that may have been taking place or other acts of discrimination that may have been taking place in the workplace. But that could be a potential for a T visa case.
Yeah, exactly. I think I've seen this question from you already, and Attorney Bria is right. Is that it may be a red flag, but we really have to talk to you to get to the bottom of it, to see what other circumstances are involved. All right. Watching from Jamaica, was a timeline at NVC to be documentarily qualified? So great question. I do want to mention this. If you're going through the NVC consular processing, please note that you should not take this process for granted. One mistake in submitting your documents to NVC will delay your case by 6 months. The reason I say this is the NVC is very strict on documents, and if you don't submit the right one, they take 3 months to tell you that. And then when you correct it, they take 3 months to tell you whether they will accept the new version, corrected version that you sent in. That's 6 months delay. So, I would say 3 months delay. So make sure that you get assistance with this, because just getting, for example, we work with the National Visa Center. We're very much aware of the qualifications, and we can do that without the potential for many delays. So this is where you need to make sure you get help. Timeline to be documentarily qualified. If you do everything right the first time, you could be documentarily qualified within 3 months of submitting your documents. All right. Attorney Deanna, you want to take the next one?
Yes. I see here. Sorry, they're repeated and suddenly they just went away. Okay. What if you have a work permit, but you are a content creator? Is that still considered as work? Yes, it is. As long as you file, of course, your taxes and all of that, it is considered as work, and you can, of course, work here legally in the US with that work permit as a content creator. Yes, you can.
Yeah, exactly. All right, so we're gonna take 2 more questions and then we're gonna head out. So, but I will be back as usual, and the 3 of us will be coming on, because I know we'll be having a lot to talk about. So we may be coming on together, we may be coming on individually, to continue to give you updates on what's going on and just to help answer some questions. I do want to make a note here. Nothing here is personalized legal advice. We're giving general information. So this is where the consultation is going to be very important. So I'm going to answer this one. My U.S. citizen spouse filed for me on October 31st, 2024. I got my work permit less than 2 months, but the I-130 and I-45 hasn't been approved as yet, and processing times are showing 52 months. So even though it shows 52 months, that they are showing the entire range of times that all the applications take. So the longest the longest processed applications are taking 52 months, but a majority of them are probably taking an average of 10 to 12 months. So it really, October 2024 was just a few months ago. So, you could expect to get an answer on those or correspondence on those in 10 to 12 months. We'll have to see what this year brings with changes and processing times. But right now, based on my experience, it's about 10 to 12 months. All right, we're doing two more questions and then we're going to have to go. So, Attorney Bria, do you have one?
Yes, I see a question. So, C. Will from YouTube asks, what happens if someone was arrested for domestic violence but was not prosecuted? Does he still have a chance of staying in America? And of course, that answer is very tricky. As we had just mentioned before, with the new administration, they will be locking down on certain people who have criminal backgrounds and determining their inadmissibility. However, in some instances, such as, let's say, the allegation of domestic abuse involved something in a domestic relationship that could concern VAWA, that could be a bit different because let's say you were arrested for domestic violence, but you weren't the actual abuser, someone else was. That can kind of be used as evidence for your VAWA case. However, like I said, that question is very tricky. So we would have to look at it very closely to be able to give you an exact answer for that.
Yeah, exactly. Whenever it comes to any kind of criminal conduct, especially when it comes to domestic violence, I know domestic violence is deportable, but I think I heard something, it was dismissed. So there's no conviction. Um, so usually you have to show a conviction, but they're still going to take a look at it and make a determination themselves based on the facts involved. So it just depends. So I encourage you to make sure you get in touch with us and schedule that appointment. That's very important at that point. And then last question, Attorney Deanna.
Yes, so I see a question in Spanish and I'm going to go ahead and answer it in Spanish. Veo aquí ¿verdad? Una pregunta en español. Estamos viendo que eres de España y actualmente estás en Francia por estado de salud. Ahora bien, si estás buscando algún consejo legal o cualquier consulta, por el momento nosotros hacemos consulta y damos consejos legales sobre inmigración en los Estados Unidos. En ese caso, vamos a pedirte, ¿verdad?, que busques a un abogado que esté en Francia o que sea de España, que pueda conocer un poco más sobre tu caso. Pero, ¿verdad?, si estuvieses en los Estados Unidos, les daríamos los consejos, ¿verdad?, bajo la ley de inmigración en los Estados Unidos. Si tienes alguna otra pregunta, puedes dejarla en el chat.
All right. Well, thank you so much. And everybody, thanks for your time. If I didn't get to your questions, we're going to continue coming on here regularly to answer questions. The way that you're going to keep up with us is please make sure that you subscribe. So as soon as we come on, you see that and you can join us as well. That's how you're going to stay up to date. I am not, so the channel on YouTube is Getting the Green Card, on Facebook, ST Law Office. On Instagram, I am Immigration Lawyer Sharifa. So you can also jump over to those platforms as well. Thanks everybody for your time. And remember, evaluate your options. We can't help you unless you help yourself by getting in touch with us. Thanks everybody. Have a great time. Thanks so much, Attorney Bria, Attorney Deanna, for your time.